Well, hello, good afternoon, or good morning, depending when you're watching me and where you're watching me. Thank you for joining me. My name is Lior Samfiru. I call myself the employment lawyer. Well, that's what people call me because I practice employment law. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us practicing employment law and disability law across Ontario, across Alberta, and across British Columbia. And why am I here? Well, hopefully you know this. Hopefully you've seen me before. I'm here answering your questions live about employment law. This is your employment law session where you get to find out the answers to the questions bothering you, where you get to know what the law does for you and how to deal with your workplace problem. I'm here for you at your service, wanting to answer your questions. You have an opportunity live right now to ask questions. I see questions are coming. Ask them. You'll get answers. You'll feel better. You'll know what to do. You'll have a better idea about your rights. Maybe you lost your job. Maybe your boss is threatening you that they're going to let you go. Maybe you're put on a performance improvement plan. What should you do? How do you deal with that? Is it even legal? Ask right now, whatever the issue. If it touches on you, your boss, your job, employment law, you're talking to the right person. You're listening to the right session. Ask your question live right now. I'll give you that answer. Now, before we get started answering questions, let me give you some contact information. If you want to connect with me and my team across Ontario, British Columbia, and Alberta, easy. Just go to employmentlawyer.ca. You see that right here, employmentlawyer.ca. And when you go there, phone numbers are there if you want to reach me off air. Email addresses are there. You can send an email. You can fill out a form. You can read lots more about employment law. So it's your one-stop shop for anything employment law at employmentlawyer.ca. But right now, me, Lior Samfiru, I'm here live. This is your employment law session. Take advantage of me being here, okay? Take advantage. I'm not always here. I'm here as much as I can. I'm here right now for you. Ask that question that's always been bothering you. All right, I'm going to start answering questions right now. In the meantime, as you're listening, type in your question, hit enter, and I'll see it, read it, answer it. Okay, N. Stinson has our first question. N. Stinson, I recognize as a regular viewer. Thank you for being a regular viewer. If severance is taken as tax-free lump sum and the former employee is on long-term disability, does the insurance company stop the payment? Does the claimant still have to continue treatment, filling out forms in the meantime, even if not receiving long-term disability benefits? So if you're not getting income, if you're getting a payment from your former employer that's not taxed, that means it's not income, then no, it's not going to impact your disability benefits, of course. So it can only impact your disability benefits if you're getting income from your employer. If it's a tax-free payment, if that's on account of general damages, on account of discrimination, on account of something bad that the employer did, then no, it's not income. It doesn't affect your insurance premium or your insurance benefits that you're getting. Now, in terms of getting exams and completing forms, you have to do what your insurance company is asking you to do. So if they're asking you to see a doctor or complete a forms, yeah, you have to do that. But very good question. The one piece of advice I'll give there is do not try to resolve the issue with your insurance company or with your employer on your own. Okay, do not. It doesn't work. It could get complicated. You can actually compromise your own rights without even realizing that you're doing that. Not to mention, your employer and your insurance company are not going to take you seriously. So if you have an issue with your insurance provider, long-term disability, short-term disability, of course, if you have an issue with your employer, ask us to help you. Get us involved right away. You can do that by going through employmentlawyer.ca. Again, employmentlawyer.ca. Okay. So let's see. Next question is from JB. To what extent does an employer need to accommodate a physical disability? My employer is saying they don't have the work or resources to provide this, but I think they're trying to make me resign. And I've seen this type of situation, JB, very often. So let's talk about that. An employer has a very strict duty to accommodate as long as that accommodation is corroborated by a doctor. So if your doctor says you need to be accommodated, the employer has to do whatever they can to find that accommodation to make that happen. Even if it's difficult, even if it's costly, your employer still has to do it. They can't say, well, this is just too much of a hassle, so we don't want to do it. Now, of course, there comes a point where it's so hard or so expensive or so difficult to accommodate that an employer may not have to go that far. But in many cases, employers say no before they reach that point when they could accommodate. So ultimately, JB, if your employer is not accommodating, but they could, they're just choosing not to, that's a human rights violation. That could also be considered a constructive dismissal, meaning you're owed severance. Okay, so you have to remember that. If your employer is not accommodating, one way to deal with that is to get them a letter from me. Once they get that letter from me, see how fast all of a sudden they're able to accommodate magically, right? So by all means, let's make sure that you do that if your employer is not accommodating you, okay? Let's not let them get away with that. It's a very strict obligation that employers have under human rights laws across Canada, is to provide that accommodation. So JB, hopefully that answers the question. Any follow-up, please, you know what to do. Ask it right now. I'll answer it. See how easy it is, everyone. You asked the question, you got the answer. Very easy to do. For those that are joining us, welcome. My name is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Why am I here? Well, I'm here because I want to answer your questions. I want to help you. I want to provide you information about your situation if it touches on your workplace. So ask the question here live. Still have time, still have plenty of time to get those questions answered. All right, let's see. Continuing to answer questions. That's what I'm here for. Question on Reddit from Sky. After having to take 2 sick days at my job, my employer has said that he stopped scheduling me. I gave him a doctor's note, but was told I need to suck it up and work harder. Can my employer just refuse to schedule me? Is there anything I can do? Well, what you're describing is a constructive dismissal, full stop. The most basic thing, the basic part of an employment relationship is that you are available for work and your employer gives you work. It's as simple as that. If your employer doesn't do what they're supposed to, they don't schedule you for work, they don't give you work, the law looks at it, it's as if they let you go. It's a constructive dismissal. So you have 2 options and only 2 options. Option number 1 is you can sit at home and keep your fingers crossed that something will change and they'll schedule you again. Not a good option, because that may not happen, or maybe they'll schedule you 1 shift a month. The second option is to say, no, I am not accepting this. This is a constructive dismissal. By not scheduling me hours, it's as if you've terminated my employment. I can consider that a termination and get my full severance. So that's probably what I would recommend here, Sky, because that's the only thing that makes sense. So if you've had enough, you just want to move on, get your severance, which could be months and months pay, let's connect. You can connect with me off air through employmentlawyer.ca. I'll give that again, employmentlawyer.ca. Easy to remember, and you see it on the screen right now. And we'll make it happen. Okay. And for everyone else, if your employer reduces your hours, doesn't schedule you for work, tells you you're going to work less, all of those things can absolutely give rise to a constructive dismissal. It's not something your employer is allowed to do. Okay. See here. Thoughtful Action has the next question. Thoughtful Action asks, I was terminated without cause and did not sign the termination offer. One issue I'm dealing with is the fact that I had accumulated a significant carryover of vacation days. I am being told that it is due to the use it or lose it vacation policy. In actual practice, carryovers were permitted beyond this date in a number of instances. So here's the thing. I mean, let me talk about vacation pay in a second, but why aren't we focusing potentially on the bigger issue, which is your severance? I don't know anything about your specific situation, but I know that in 90+% of cases, the severance that you're offered is a lot less than what you're owed. And that can easily be thousands, tens of thousands of dollars, okay? Even more than that. I almost guarantee you that that aspect of it is a lot more than the vacation that may be outstanding. So let's deal with that issue first, okay? The other thing with respect to vacation, you can lose vacation time. You cannot lose vacation pay. So if you've accrued certain number of vacation, a certain amount of vacation pay, they have to pay it out. So when you're working, if you didn't take your vacation days, you may lose those, but you can't lose your vacation pay. Your employer still has to pay you. So yes, they have to pay you that vacation pay, but I bet you anything, without even knowing how much money at stake is here, is that the real issue financially is the severance. So call my office, reach out through my office through employmentlawyer.ca. Again, employmentlawyer.ca. Let's get you what you're owed. That severance, that vacation pay. There may be other things you're owed. Maybe there's an accrued bonus that you're owed. Maybe there's other entitlements, benefits, etc. So let's have that discussion. Connect with me and my team. Again, employmentlawyer.ca. Okay, so hopefully that helps. Let's talk about that. You know how to do that. And for those connecting right now, welcome aboard. Thank you for joining me. My name is Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here for the next 20 minutes or so for you, answering your questions live. See how easy it is? I've been answering questions nonstop here. Ask yours as well. Let's talk about that. Let's make sure that you understand the law, you understand the rules, you understand what you can do if you're facing a workplace issue. Type it in, hit enter, I'll read it, I'll see it, and I'll answer the question. So if you've just joined me, ask the question. All right. Mary Lou, what is the timeline for grievance? Well, if you're using the word grievance, I'm assuming you mean in the union context, and that's something you have to ask the union. The answer is in your collective agreement. Only the union can file a grievance, and it's in their discretion whether to file it or not. And the collective agreement will tell you how long the union has to do that. All right, Roland has our next question. If I'm getting paid $25 an hour, can it be inclusive of both statutory and vacation pay? It can, as long as that's clearly outlined in your employment agreement. So really your hourly rate is less than 25, but with vacation pay, etc., it comes to 25. Yeah, that's okay, but your employer can't decide that after the fact. So if you've agreed to earn $25 an hour, and then after the fact, your employer says, oh, by the way, we've decided that that's inclusive of vacation pay, no. But if the deal was 25 is inclusive, that would be legal, but the employer would have to prove that that was the case, that that was the deal, that was what was agreed on when you first started working. Okay, good questions. Fantastic questions. You guys have the best questions. That's why I like being here. So do it again. Let's get some more questions answered. More have just come in. I'm going to continue answering them. But don't leave your question to the last minute. Every week. Last week it happened again. I was here answering question. I was saying goodbye. All of a sudden, 2 more questions came in. Don't do that, okay? Let's make sure you get your questions answered. So type them in right now. You still have plenty of time. N. Stinson has another question. Can you help if the employer or insurance company refuse to provide copy of long-term disability contract? Yeah, but honestly, I've never really heard that being an issue. Oftentimes you can even get that online. But yes, I mean, certainly if you ask and you don't get it, if they hear from me, they'll provide it. But I really haven't seen that being an issue. Mayuri says hello. Well, hello, Mayuri. Nice to have you join us. Ask your question if you have a question about employment law. Stephen does have a question, and Stephen's question is, the plant I work for is scheduled to close at the end of the year. My position is being moved to a different facility, but it's around 2 hours away. If I refuse the position, is that a resignation? So if this is going to increase your commute by 2 hours or so, that's not a resignation. That's a constructive dismissal, okay? That's a constructive dismissal by changing the terms of employment in such a way. So now instead of commuting this amount, you're commuting 2 hours more. That's a significant change to the terms of employment. You can treat that as a termination of employment. But here I'm going to give you a little trick because they gave you some notice. They told you in advance that at the end of the year, you're going to be moving away. They're going to want to rely on that notice to reduce your severance. So one way to deal with that is to say, employer, I'm very concerned about this move, but I'm going to try it out. Once we move at the end of the year in January, I'm going to try it out and see if it's as bad as I think, and I'll let you know how I feel about it then. So come January, try it out for a little while. If you kind of like it, it's not so bad, great. If you still hate it, it's too hard, you can still say constructive dismissal, and your employer doesn't get credit for the notice that they gave you. Okay, so the answer right now is, I'm very concerned. I don't know if I can do it, but I'm going to try it out in January and let you know how it is. Hopefully that makes sense. If it doesn't, call me. And if in January you decide to pursue a constructive dismissal, before you tell your employer that you're resigning or you're leaving or you can't do it, you call my office, Okay, we do this right, we do this appropriately so that you can get the maximum severance that you are owed. And for you to contact me, you know what to do, employmentlawyer.ca. Again, employmentlawyer.ca. Now, I mentioned to Stephen, I mentioned to a few other people, severance, the severance that you're owed. Well, how much severance are you owed? How much severance should your employer be paying you? Is it a week for every year? Is it 2 weeks for every year? No, it's not. Nonsense, not even close. Here's how you find out right now how much severance you are owed. You grab your smartphone, your tablet, your desktop, your laptop, whatever you want, and you go to pocketemploymentlawyer.ca. You see that on the screen over here, pocketemploymentlawyer.ca. You'll see our severance calculator tool there. You click on it, and that's it. You can then do a severance calculation. You answer a few questions, and it's going to tell you how much severance you are owed. Maybe you're owed 6 months, maybe you're owed 22 months or something else. It's easy. It takes seconds. It's completely free. No credit cards, no names. It's anonymous, no company names. No one's going to know you've ever been there. It's something that you need to do so that if you're losing your job or will lose your job, you're not taken by surprise. You'll know how much you're owed. And you'll know if that severance offer that you got, if it's appropriate or not. Chances are, over 90% of chance that whatever you've been offered is less than what you're owed. So a great place to start is the severance calculator at pocketemploymentlawyer.ca. And if you want to, and only if you want to, you can connect with me, contact my team and myself from the severance calculator tool. So there's a green button at the end. You can click it and contact me if that's what you want to do. So check out pocketemploymentlawyer.ca. But right now, I'm Lior Samfiru. I'm here live with you for the next 10, 12 minutes or so, answering questions. So if you have a question about employment law, ask it. Don't hesitate. Don't be bashful. Don't sit on the fence. Just ask the question. I'll answer it. I'm going to continue answering questions right now. Okay. Question on Reddit from AK9. My employer is asking me to resign upon returning from maternity leave. I worked in a remote position prior to my leave. They outsourced my job to an agency and say they don't have a similar position for me. If I don't take an in-office job now, they will consider me voluntarily resigned. What can I do? Well, there's a lot of stuff happening here. Number one is your employer has to take you back. They can't decide to give your job to someone else. They have to take you back after maternity leave. Same job, same terms, same pay, same everything. Okay? So right off the bat, if they don't do that, that could be an employment standards violation. It could be a human rights violation. Illegal. They can't just do that. Second, even if we somehow forget about that, which we're not, but let's say we did, the fact that they change your job in such a significant way is a constructive dismissal. So if you don't go back, that's not a resignation. That's a constructive dismissal. Can't do that either. So this is illegal here, AK9. So before you do anything, before you respond to the company, before you tell them yes, no, maybe, before you do anything, you contact my office. We have to do this right. We can't leave this to chance. We can't do something and then just hope that it turns out okay. Contact my office through employmentlawyer.ca. There's a lot that your employer is doing wrong here, so let's not take any chances. Okay, employmentlawyer.ca, AK9. Reach me, my team. Phone numbers are there. Email addresses are there. Very, very easy to connect. All right, I'm going to continue answering. You see how easy it is, just like AK9. Ask yours with me. I'm Lior Samfiru, the employment lawyer. Meiri asks, sales job where paid base salary plus incentive commission. Can an employer keep changing the way the extra commission will be calculated? Well, they can't unless you sign an employment agreement that says that they have the right to do that. So if you sign an agreement when you start working saying we can decide how to change the incentive compensation however we want, anytime we want, if you sign something like that, then they can do it, right? The other way they can gain the right is if in the past you allowed it to happen. So let's say a year ago, they changed it and you weren't happy, but you accepted it. Well, by accepting it then, they now have a right to do it again and again. But if you never sign anything that gives them the right to change it, and if you haven't accepted this situation before, then they don't have a right to do it. That could be a constructive dismissal, depending on what they did. If it's a tiny little minor change, it may not be. But if it's a significant change to how that incentive compensation is calculated and how much money you're going to earn, that could absolutely be a constructive dismissal. So Meir, we probably should talk about this off air. To connect with me and my team, employmentlawyer.ca. All right, Liz on YouTube is up next with her question. Constructive dismissal is after giving employer notice of need for disability accommodation and they go silent. How long to communicate? Not sure. I think what you're asking is you're telling your employer that you need accommodation. They haven't responded. How long before it's a constructive dismissal? So you want to follow up with your employer probably a total of 3 times. You ask them again, and then you ask them one more time. Okay, after about 3 of these efforts, if they still don't respond to you, they don't give you a meaningful answer, that could be a human rights violation. That could be a constructive dismissal. It's illegal. But you want to follow up. Probably follow up within a few days or a week. So let's say you send a note today, you follow up in a week, and you follow up in another week. If by then there's no response, yeah, absolutely, we're going to be in a position to say human rights violation and a constructive dismissal. So do that follow-up. By the way, the follow-up in writing, email works perfectly. You don't want the company to say, "Oh, we missed it. We never got it. You never called us." Send an email. Okay, very important. And if you still don't get a response back after those 3 tries, call me before you do anything else. Employmentlawyer.ca to connect with me. Phone number, email addresses, it's all there at employmentlawyer.ca. Okay. Thoughtful Action says, how far back in time does the employer is the employer obligated to pay regarding accrued vacation pay? So if you continue to accrue it, so in other words, before you were let go, if it was still owing to you and the employer acknowledged that it was owing, then you get it, even if it's 15 years ago. If the employer and you never agreed that it was owing, that you can go back 2 years. Okay, so hopefully that makes sense. By the way, with respect to accrued vacation, for that, you can file a claim with the Ministry of Labor if that's what you want. You cannot do that. Cannot do that with respect to your severance. With respect to your severance, government cannot help. In fact, the government, by filing a complaint with them, you may be prevented and barred from pursuing your full entitlements. Can't do that ever, ever, ever. But you can certainly go there with respect to vacation pay. Hopefully that makes sense. Okay, we have some time for some more questions, so you can get in a question still. So don't hesitate. Just ask. You'll get the answer. Let's see. Stephen, I think, has a follow-up. What exactly does constructive dismissal mean, and how does it work? Is this something I should mention to my employer? Well, constructive dismissal is a situation that because of something that your employer did to you, you are choosing to consider it as a termination of employment. So let's say your employer reduced your pay or changed your hours or changed your job. They made a significant change to the terms of employment. You can then say, wait a second, employer, by changing my job that way, I am deciding that this is now a termination. And because of that, because I made that decision, employer, you now have to pay me my full severance. So a regular dismissal is a situation where the company lets you go. A constructive dismissal is a situation that you've decided that they let you go because of something your employer did. But no, if you can mention it to your employer, they're not going to agree. To pursue it, we have to do this properly. We have to engage in the legal process. So if you think you're in a constructive dismissal situation, if you want to get your severance, you don't want to accept what your employer did, you have to call me. Okay, you cannot, practically speaking, pursue this on your own. And if you say constructive dismissal to your employer, it's not like they're going to say, "Oh yes, sure, here's a check." We have to do this properly. So to connect with me and my team, as I said before, Stephen, employmentlawyer.ca. Again, employmentlawyer.ca, and we'll get going. Let's see. Question here from YouTube from JT. What can you do if your employer's verbal offer and the employment contracts are entirely different hours, rate of pay, etc.? So ultimately, if you sign an employment agreement, that's what governs. If you had a different deal verbally with the employer, that deal is gone. It's over. So if you had a deal and then they follow up with an employment agreement, then go back to them and say, "Hey, employer, we agreed that I'm going to work 38 hours. This says 25," and negotiate those terms. But never sign an employment agreement thinking, well, I signed that agreement, but it doesn't matter because verbally they said something different. No, whatever that verbal promise was, doesn't matter. It's gone once you sign an employment agreement. Okay, so that document that you signed, the employment agreement, the job offer letter, the employment contract, whatever you want to call it, that is the document that matters. And oftentimes there's many problems with that document. There could be terms in there that limit your future severance. It could cost you tens of thousands of dollars. There could be terms in there that allow the company to put you on a temporary layoff. Terrible thing to be able to do. Terms that allow the company to reduce your pay, change your job, to demote you. Very, very important that before you sign an employment agreement, this applies to all of you. Before you sign an employment agreement, whether you're working in a entry-level job or a very senior job, have my team and myself review it. Okay, let's have that conversation. Don't sign something and then realize, holy cow, that was a mistake that I made. Happens all the time. Don't let it happen to you. Okay, another question. This may be the last question on YouTube from Lisa. When working with a time card for your employer, how much are they allowed to adjust your time before it is considered illegal? If they are removing 15 minutes from the beginning or end of a shift, is this allowed? No, they're not allowed to change your card at all. So if you're working, you have to get paid for the time that you've worked. Okay, it's as simple as that. So they can't reduce it by 15 minutes, 30 minutes. It's not up to them. If you worked, you have to get paid. Now, if you forgot to punch out, maybe because you were late somewhere, and then they can adjust it. Or if you punched out late because you forgot and you came back, no problem. But if you punched out when you were done and you had to work, then they have to pay for the time worked. It's as simple as that. Okay, I said last question, but I see something just came in. I'll answer that last. Thoughtful Action has a follow-up. Do you only take clients on a contingency basis, or do you provide other options too? Yeah, we provide other options too. There's a few options, and every case is different. In some cases, we only have potentially one option. Other cases, we can have 3 options, depending on the case, depending on what's involved. But the best way to know what's involved and what your options are, just contact us. If you have a legal matter, contact us, set up that consultation, and we can discuss all those issues. Again, to connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. Guys, this is the time that I have for today. Thank you so much. Great questions, lots of them coming in. Really appreciate you being here with me. Remember the tools that I gave you, employmentlawyer.ca and pocketemploymentlawyer.ca to use our severance calculator tool. First place you go to if you lose your job. Thank you so much for joining me. Thank you for asking the questions and giving me an opportunity to help you. My name is Lior Samfiru. I'm the employment lawyer with Samfiru, Tumarkin, LLP. I'll be back here soon. In the meantime, reach me through employmentlawyer.ca. Thank you, everyone. Have a wonderful rest of your day.